नमस्कार। सबसे पहले मुंशी प्रेमचंद जी को दो शब्दों में श्रद्धांजलि। प्रेमचंद जी की रचनाएं बताते हैं कि एक साहित्यकार को निडर होना होगा क्योंकि उसकी अभिव्यक्ति की स्वतंत्रता ही समाज में बदलाव की नींव डाल सकता है। With this tribute to Munshi Premchand, whom all of us have been reading from our childhood, I place for you a few points for consideration. First, it is not correct that restrictions on free speech are a recent phenomenon. How do we deal with it now? Restrictions on free speech have been there for as long as the state has existed. And let's come to the Constitution of India, 1950. So the first free speech cases were decided by the Supreme Court in 1950 itself. Ramesh Thapar, Crossroads, Communist Weekly. Brij Bhushan, organizer, RSS Weekly. Both faced restrictions in the first year of the Constitution, and the Prime Minister was the Democrat Jawaharlal Nehru. So, the point which I wish to make is that the very structure of a constitution which gives rights to the citizens and at the same time gives power to the state to impose restrictions, creates this tension, this state of confrontation. So today, I am not in a position to offer you legal solutions as to how restrictions can be avoided or how writers can be safe. That situation can't exist. You don't live in that utopia. There has to be this creative tension, this constant confrontation. And that is how democracy will thrive. When we are talking of increased instances, all that we are seeing now compared to the past is that because of modern technology and easier communication, internet, social media, etc., therefore there is greater scope for people to express themselves, and there is greater scope for the state to notice, and there is greater scope for complainants, some genuine, some busybodies, to complain. So this increase which we are seeing is only as a result of more means of communication being available. Now, one of the questions posed in the program, in the invitation to speak, is who is to judge? How do we arrive at a balance? Now, the first question, who is to judge? The answer is the judge is to judge. But then there is one more question, who is the judge? Is the judge an LLM from Harvard, a woke judge? Or is the judge an LLB from Kurukshetra, steeped in Indian family values? Therefore, depending on which court, which judge your case goes before, the standard of restriction will vary. And that's a fact of life, whether it's in India or in America. In America, you may be before a Republican-leaning judge or you may be before a Democrat-leaning judge. So a lot depends on the makeup of that particular judge. Now, judges will be presumed to know what the Constitution permits and what it does not. But in this very recent instance which Mridulaji spoke about, one is having a little doubt about whether judges know what the Constitution says, for the reason that when the CPM went to the Bombay High Court against an order refusing permission to hold a public meeting or a rally on the question of Palestine, the fundamental right involved was not right to free speech under Article 19(1)(a), but the right to assemble peacefully under Article 19(1)(b). Now, friendly relations with foreign countries is a ground of restriction under Article 19(1)(a), freedom of speech. But friendly relations with foreign countries is not a ground of restriction under Article 19(b). This, the Bombay High Court doesn't seem to have realized when it said, you want to speak in favor of Palestine, do you understand the international impact of what you're doing, and now look after municipal issues, etc. So this presumption of knowledge of the Constitution itself may not attach to all judges. And I think, it's a rare thing that the CPM Politburo has passed a resolution condemning this view of the Bombay High Court. It's something very rare that a political party condemns the view taken by a High Court. Of course, they could have appealed to the Supreme Court, perhaps they are. But the fact that they have found it necessary to publicly censure the Bombay High Court, I think it was something necessary and overdue, because if such remarks are made by a constitutional court, then there is reason for us to worry. Now, not everyone is like Mr. Anand Patwardhan, who can take his case right up to the Supreme Court and win thumping judgments, as he did a few years back. The effect, the chilling effect, is more on ordinary citizens who are dependent on intermediaries like Google, Twitter, whatever. How many have the capacity to challenge orders of takedown? This is the real danger. On the one hand, technology has afforded greater access to citizens to express themselves. But on the other hand, with restrictions like those placed by Section 66A of the Information Technology Act, the ordinary citizen is stifled by the threat of takedown. And that is an unfortunate part of our life today, a citizen's life today, in spite of greater means of communication. A couple of other aspects I want to highlight for your consideration. Now, when you go to a court asserting your right to freedom of expression, the judge may give you protection but express his views or her views depending entirely on his or her personal makeup. Now, for instance, there was Ranveer Allahabadia, who said something which most of us would feel embarrassed about. Now, when it comes before the court, the judges are also people in their 50s and 60s. They are fathers, mothers, grandfathers, and grandmothers. So they do express themselves strongly, even while affording protection. Then the question arises, should judges be doing moral policing? Should they be advising people what they should say or not to say? Now the point is, a judge can't divorce himself from his personality to such an extent. This is a price you have to pay when you go to the court. If you exercise your right to shock and offend, then you should be prepared for the judge also, while giving you reluctant protection, to give you a lecture on how you should or should not conduct yourself. Or you take the case of the Professor Mahmoodabad. Now, what is the price which he paid to get protection from the Supreme Court? That he would not make any further comments on the war with the neighboring country. Now that one would think was beyond the scope of his petition, but that is the price which he had to pay. An SIT is set up. The SIT goes into various other things. Then the court cautions him, saying, no, that was not your remit. You are here to just interpret these words in his tweet. Now we have to ask ourselves, what is it that 3 IPS officers are capable of interpreting, which 3 learned judges of the Supreme Court are not capable of interpreting and understanding? So these are some of the problems or contradictions which come up when you go to the constitutional courts for protection. I must just conclude with a reference to Mridula ji, who, as I said, was a heroine for me from my teens, because I read her work in translation. She also faced a criminal case for one of her great works. But then she is in the company of D.H. Lawrence, and who said that the work of D.H. Lawrence, that Lady Chatterley's lover, was obscene. It was not an ordinary Indian educated traditional judge. It was a barrister judge, Hidayatullah, Cambridge educated. If someone knew literature, it was a judge like Hidayatullah. And so, if someone like him, of his erudition, of his worldview and his exposure, can find D.H. Lawrence to be obscene, then what protection can you get from people with less impressive credentials? Thank you.